Hey there, Legal Tea listeners. This is your host, Jenny Roselle. Today's episode is a cautionary tale topic, a cautionary tale type of episode. And usually on these episodes, we go into a real-life case, a real-life client story that I or my office have worked on. And it's usually in some sort of messy something that's happened that you should honestly learn from. Today is a topic that was actually inspired by a friend of mine that texted me super recently asking about the process of someone getting appointed as an executor. And kind of long story short, she had shared that her partner's grandparent had passed away and that there was all this drama and messy stuff going on. And it was really about, one, who should be appointed as the executor, and two, what happens if not everyone agrees to who they think should be appointed. So when she texted me this, it totally reminded me of a case that we were involved in maybe a year or so ago, where my office assisted with probate, which is the court venue to get someone appointed as an executor. Now, it is important to understand that probate is the court process that sometimes happens depending on estate planning documents and asset ownership after someone passes away. So it sometimes happens. It just depends on a lot of little things. And sometimes people think that when you have a will, like a last will and testament, that avoids probate. And it does not. So a little news flash for you. Just know that probate may happen if there is no will at all, or even if there is a will and we are relying on that will to get an asset from a deceased person to the will's beneficiaries. So through the probate process, someone gets appointed as the executor, right? Indiana, I suppose I should probably be, technically appropriate. Indiana likes to be different because when I say executor, most people know what I mean when I say that. But here in Indiana, we call that role a personal representative. They are, an executor, a personal representative. They're the ones in charge of the estate. So hiring an estate attorney, consolidating assets, administering the estate, distributing to the beneficiaries, etc., etc. So just know that when you hear executor, when you hear personal representative, they're kind of one and the same. So the cautionary tale episode today is about a family that was not fighting about the money. And they were not fighting about who gets what, but instead they were fighting about who was in control. That is, who should be the executor or the personal representative of their mother's estate. It all began when one of the children met with my office, and they engaged our firm to represent them as the personal representative, and we got to work. All of a sudden, we get a phone call from one of the other children, so a sibling of this person, and that person is so mad, I tell you, so mad. That child was saying, to stop all work. She was the one in control, blah, 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 blah. So you see, the kicker with this case is their deceased mother did not have a will. So when you don't have a will, really anyone can petition to be appointed as the personal representative, as the executor. And actually, we're going to talk about that here in a little bit, who should be appointed as the personal representative. So hold on, just hold tight for a second on that. So we pushed forward with representation. We petitioned the local court to get our client appointed as the personal representative, and the court ordered it. So officially, our client was the personal representative of their mother's estate. Now that's all fine and dandy until we got another call from that child that was real mad. Most of the calls from this child were to be quite honest and frank, were borderline inappropriate. She threatened my team. She was screaming. So I actually instructed my team that when she called, to listen, but to let things bounce off of them, to put a note in our database, email the attorneys like what that person said, and just move on with their day. So one of these calls, she said something to one of the team members, and they subsequently relayed to us, that prompted me to think, what does that mean? And specifically, it prompted me to pull up the court's records, and I discovered that she had hired an attorney herself, and they had opened an entirely separate estate case for their mother, but had incorrectly spelled the mother's name, and that's why the court did not put two and two together. I can't make this up. This is all very factual information. So at this point, we've got two attorneys, us and then the other child's attorney, as well as two estate cases with the court. So to no one's surprise, the court called a hearing basically to say, like, what in the heck is going on, people? Rightfully so, I may add. It felt like a circus there for a while, and it was after meeting with the clients, but before this hearing, that both sides started airing out major dirty laundry. It was uncovered that one side had criminal charges on their record, specifically drug-related charges, and the other side had like major creditor issues on their record. Both sides' attorneys started wondering, okay, maybe none of these people should actually be the personal representative. So both sides' attorneys, us and then that other attorney representing the child that was real mad at us, we basically both recommended to our respective clients, hey, what if we appoint a third party, non-family member professional to serve as the personal representative? And I'm sure this won't come as a surprise, but nonetheless, to this day, I'm 100% convinced that they just kept fighting because it was about winning. Like, what side was going to win the argument? Whoever the personal representative got to be is the one who won. They were the ones that are in control, right? So I'm not sure why they thought that because serving as personal representative, like, is some, cool, super awesome thing. But it's no small feat. It's not an easy job, and it takes a lot of time and energy. But here we are. What is equally as crazy as all of this is about rambling on what's going on with this estate, was that this estate was actually really small, like monetarily in size. The estate was a house that was worth about $75,000. So that is what this mother who passed away, that is all she had in her name. So from a mile away, I can see that this estate has the major possibility to get consumed by legal fees, all because these beneficiaries cannot agree on who should be the personal representative. And, I think what breaks my heart through this is, again, they weren't fighting. A lot of people think when money's on the table, that's when people fight. And I guess money was technically on the table. But again, they weren't fighting about the money. They were fighting about who was going to be in control, right? Alrighty, so now that you kind of have a little bit of the story, I'm going to pause on the actual story and kind of give you a little bit of factual information as to like who can serve in this role. So let's talk a little bit about who, according to the Indiana Code, should be appointed as the personal representative. And secondly, what sort of like qualifications should that personal representative possess in order to be appointed? So on the who should be appointed, this podcast is based out of Indiana, and so I can really only relate to what our Indiana Code states. I'm going to guess that a lot of states follow very similar statutes. and laws, but I would definitely, if this is something that is very near and dear and pertinent to something in regards to you, please speak to an estate attorney in your state. Okay, so Indiana says that the following individuals should be the personal representative in someone's estate in the following order. So yes, there's kind of like this hierarchy that more than likely a judge will agree to if you're, petitioning to be the personal representative. So first, number one is to the executor or personal representative designated in a will. Then number two is to a surviving spouse who is also a beneficiary in the will. Then number three is to a beneficiary in the will. Then number four is to someone that the surviving spouse nominates. Number five is an heir. Number six is, quote, any other qualified person. So as you can see here, the mother's estate, she did not have a will, remember? So that very first one where it says, an executor or personal representative designated in a will, well, she didn't have a will. So after all the scuttlebutt, just to kind of fast forward a little bit, the court actually ended up, after a lot of court back and forth between the attorneys, decided that an attorney, a third-party, unbiased professional, an attorney, should serve in the executor personal representative role. And honestly, that's exactly what should have happened. Like I said earlier, that's what we had proposed. But none of the parties wanted to agree to that. So because we didn't have agreement from them, ultimately we were left with basically like, hey, court, you decide who is going to be the executor of this estate. Okay, so secondly, let's chat about what qualifications the personal representative or the executor should possess in order to be eligible for the appointment. So again, this is Indiana. So just double check with your own state if this is something pertinent to you. Okay, first, a personal representative must be at least 18 years of age. So they got to be 18 or older. Number two is the personal representative cannot be incapacitated unless the incapacity, of course, is merely physical. However, if it's cognitive incapacity, for example, it can't have that. Number three, the personal representative cannot be a convicted felon. Number four, a personal representative, if it's a corporation, must be authorized to act as a fiduciary within the state. And number five, a personal representative will not be appointed if the court finds them unsuitable. And I love that last one. It's a nice little catch-all, right? So anchoring back to this cautionary tale case, like I just said, to no one's surprise, the court ended up appointing that third-party, unbiased, professional attorney to serve in this role. And it's likely because the court found that the personal representatives were unsuitable. If you recall, one of them had drug charges, the other had creditor issues. So yeah, that was probably enough from the court's perspective just to say, sorry. And kind of even beyond this current cautionary tale case I'm talking about here, we actually once had a case, a totally different case, where the proposed personal representative had creditor issues, yet no one opposed to this person serving as the executor, as the personal representative. But the judge called us in and said, no, sorry, I'm not having them as the estate representative. They have creditor issues. I can see that on the court's record. So obviously the court takes this appointment very, very seriously, and as they should. When you are appointed in this role, you are held to a very high standard called a fiduciary standard, and you have to always, always, always work in the absolute best interests of the beneficiaries. So the court puts an immense amount of trust in this person to fulfill the duty, the personal representative duties. So along these lines, I wanted to quickly mention, just as we sort of wrap this episode up, is that there are two types of estate administration through the court. There's supervised or formal, and then there's also unsupervised or informal. Now, many estates, they fall in the unsupervised category, meaning that the court, once they appoint the personal representative, is not really breathing down your neck. The court just, again, puts a lot of trust in the attorney that is representing the personal representative to make sure they do their job completely and accurately and in the best interest of the beneficiaries. However, some estates fall in the supervised formal category, meaning that the general rule of thumb is that the court must approve pretty much everything before you do it. So many estate litigation cases fall in that category, the latter. Or sometimes they even fall in this category if the beneficiaries do not consent to that proposed executor. The court will also set it as supervised or formal. Of course, in supervised land, the attorney's work dramatically increases, right? Because we have to prepare petitions and motions, asking the court to do things before the personal representative does them. Conversely, in the informal, unsupervised land, we don't. Most things just kind of happen off the record, so to speak. So going back to this case, this had to be set as supervised because obviously the parties were not agreeable to anything, but most especially to who should serve as the personal representative. But I wanted to mention that just as sort of the more that you know, but this was also another reason why the legal fees drastically increased, was for that very reason. Alrighty, I am over time. I am so sorry. I always try to keep these at like 15 minutes or so let's wrap this episode up. Next week, we are back to the current events, current trends topic. Something I've seen or run across that I think would be interesting on here. During next week's episode, we're going to be talking about the movie The Blind Side. I hope you've seen it. What a wonderful movie. But there appears to be some drama in a court case that has started brewing between the real life people that has inspired that movie. And it's getting juicy. So tune in next Tuesday. Until then, Legal Tea listeners, be well and talk soon.